I'd like to welcome you to Recent Trends in Premarital Agreements. I am April Zanis. I'm the co chair of the Beverly Hills Bar Association's Family Law Section. We are proud to bring you fantastic continuing education opportunities like today's program and are so grateful to the people who volunteer to provide us with their ongoing knowledge and involvement. We have a program on monitored visitation on July 16th with Judge Lopez Gis, Michael Hanasab, and Robin Sachs, and a program entitled Mediating a Divorce After a Natural Disaster on July 24th with Judge Diana Gould Saltman and Craig Lipsey. I am delighted to introduce today's speakers, Lauren Petkin, Mickey Katz, and the Honorable Elizabeth Scully. Lauren Petkin is the founder and principal attorney of Lauren S. Petkin Family Law and Mediation in Los Angeles, bringing over 34 years of family law experience to her practice. A former attorney at two of LA's leading family law firms, she has handled complex cases involving high asset estates, contentious custody disputes, everyone's favorite, and marital agreements. Known for her intelligent and compassionate approach, Lauren is dedicated to helping families navigate legal challenges with skill and sensitivity. Mickey Katz is the founder and principal attorney of the Law and Mediation Offices of Michelle Katz, serving clients across California. She is a certified family law specialist and focuses on consensual dispute resolution in divorce and family law matters. With extensive experience in mediation and collaborative law, she is dedicated to helping clients find meaningful, non litigation solutions. And the Honorable Elizabeth Scully serves as a judge on the Superior Court of Los Angeles, bringing decades of experience in family law to the bench. Following her admission to the California bar, she practiced at prominent law firms and later co founded Jacobson Scully, LLP. A certified family law specialist, Judge Scully also contributed to legal education as an adjunct professor at UCLA School of Law and Whittier College of Law. Her dedication to public service includes leadership roles with the Beverly Hills Bar Association and nonprofit family law organizations. She was appointed to the bench in 2020 and was reelected in 2022. And with that, let's get started. Lauren?
Thank you, April. So you introduced us. Thank you, everyone, for joining. The goal today was to provide an update. Mickey, Judge Scully, and I did a program in February 2022 for the Beverly Hills Bar on premarital agreements. So the goal today was to update with any new case law and also focus on the issue of unconscionability because it's a hot topic in drafting of spousal support waivers and limitations, as well as the overall agreement. So I'm going to start with a case that came down after our last program called Estate of Escra. It's in your materials. It was published in May 2022. And although it was a probate case, it did involve a premarital agreement, and the holding of it is important. So in this case, parties got married in May 2015. Husband passed away in an automobile accident in 2018. Wife's request to be appointed as the personal representative of the estate was denied because she signed a premarital agreement waiving her probate rights as a survivor spouse and waiving her interests in husband's separate property. So the facts are sort of interesting, and it's a cautionary tale, I believe, for practitioners when they deal with their clients and drafting agreements. Shortly before their marriage, husband told wife, and we'll call her wife number two because he was previously married and had a child. He told his wife he wanted a prenup. He met with his lawyer, and he told his lawyer he wanted the prenup to provide that his separate property would remain his in the event of death or divorce. Husband told wife that he had met with a lawyer to deal with these things. The agreement was sent to wife's counsel, and wife met with her counsel for 90 minutes and who explained the prenuptial agreement to wife number two. Wife number two was very upset because she did not believe that husband had informed her that the agreement would apply in the event of death as well as divorce. She told her lawyer that she wanted the probate clauses um, redacted. That's the words the case used, which probably was removed. Wife's lawyer testified at the trial wife testified at the trial that she told husband that she did not want the agreement to apply in the event of death, and that husband had agreed. So wife's lawyer sent an email to husband's lawyer stating that it was the parties' mutual intent that to protect husband's property in the event of divorce, but not in the event of his death. Wife's lawyer asked husband's lawyer to remove several probate provisions that waived the surviving spousal interests. Now, at trial level, husband's lawyer testified that husband confirmed, because husband was deceased and couldn't testify, that husband confirmed that he wanted the prenup to apply also in the event of his death. Husband's lawyer said that he responded to the redactions that wife's lawyer requested because they were inconsequential and they were merely examples. But the applicable part of the agreement, waiving the surviving spouse's interests in the event of death, remained. Husband's lawyer testified he provided wife's lawyer with a revised agreement, and wife's lawyer was unable to explain why she failed to request the redaction of the operative probate provisions. Wife apparently did not receive a copy of the amended prenup before she signed it. Wife's lawyer had hoped to see wife again before her client signed the agreement, but she didn't. The parties signed the agreement on May 1, which was the day before their wedding on May 2, and wife testified that she signed it without looking at it, and her lawyer was not present. There was no discussion of the PMA. PMA was merely a signing. Wife assumed that the changes that she had requested had been made. So this is already a red flag dealing with wife. The trial court heard testimony that husband intended to leave all of his property to his child from his first marriage in the event of his death. And the court heard testimony that he wanted an agreement to make certain this would happen. So the trial court found that the doctrine of mutual mistake did not apply because husband was not mistaken when he signed the agreement. The court agreed that wife too and her lawyer did not want the agreement to apply in the event of husband's death, but her unilateral mistake was insufficient to justify rescission of the agreement because there was insufficient evidence that husband had encouraged her or fostered her mistaken belief. The court found that wife bore the risk of her mistake because she did not act with reasonable care when she failed to read the agreement and failed to consult with her attorney after it was revised. The Court of Appeal affirmed the trial court on a somewhat different basis. It held that the failure to make a reasonable inquiry to ascertain or make an effort to understand the meaning and content of the contract precludes rescission for unilateral mistake. A party may rescind a contract when consent was given by mistake, provided the mistake is not caused by the neglect of a legal duty on the part of the person making the mistake. So wife's mistake was she did not know the facts as they were. She had a mistaken belief as to the legal consequences of the real facts. She could not argue that her execution of the revised agreement was due to any mistake of law by her lawyer because she and her lawyer never discussed the revised agreement. The court said, quote, "The mere fact that a mistaken party could have avoided the mistake by the exercise of reasonable care does not preclude avoidance on the grounds of mistake." So the key was wife's failure to read the revised agreement and consult with her own lawyer to ensure that she understood its contents and meaning, and it was a dereliction of her duty, which precluded her from getting relief. The court also said, quote, "Failure to make reasonable inquiry to ascertain or an effort to understand the meaning and content of the contract upon which one relies constitute neglect of a legal duty and such as will preclude recovery for unilateral mistake of fact. So, wife's failure was profound. She was aware of the draft. She was aware that there were probate waivers in the agreement that prevented her surviving spouse rights that were disturbing to her because she talked to her husband. That should have led her to exercise additional caution. It should have led her to read the revised agreement. I mean, this case to me is so clear cut right, but it is a cautionary tale for practitioners that you have to make an attempt to go over the agreements with your client. We can't force our clients to read them. We rely on the fact that they read them. We do our CYA letters. We have initials on the agreement that says, I've read and understand every page. And Judge Scully, is there anything else you would like to add to this, to the case that, in my opinion, was rightly decided?
Thanks so much for including me. It's a pleasure to be here. Um, yeah, I think always there are lessons to be taken from drafters and from people that are working as consulting attorneys for parties negotiating and entering into these agreements. And there is a lot that you all can do to make sure that there's clear documentation and opportunities to confirm that someone has read and understood it. Lauren mentioned some of those, examples, clear anecdotal examples and agreements, drafting using as little legalese as possible and clear layperson's language can help. Provisions that people have to initial can help. Videotaping signing ceremonies can help. And having recitations and agreements that set forth the timelines pursuant to which things unfolded and or if you're the consulting attorney or the attorney of record, making sure that your notes and your billing records are very clear about when you met with the client and how often and how long the meetings lasted, and documenting what took place so that you're protecting yourself against the implication that this didn't happen, and more importantly, so that you're really making sure that people don't sign things that they don't understand, and that your job as the gatekeeper of making sure clients have informed consent is well done. Because of course, I protecting the interests of the professionals is of course, important to everyone, but also making sure that people aren't in this situation. And I'd comment too, I do see arguments a lot to the effect of, I had no idea what I was signing. I didn't read it. I relied on other people. And it always surprises me. I wonder if there's some sort of vestigial wishful thinking from back in the day when premarital agreements were less customary or before the Uniform Premarital Act agreed, when people sort of have a sense that it doesn't really count and you're going to be able to get out of it by just sort of throwing up your hands and saying, I was focused on, wedding details and I didn't read it or whatever, the reason is. And I think, it's that kind of argument is challenging for the judicial officer because I think the law is clear, and the law that's cited in the case that people do have a responsibility to act with basic self-preservation and, to take seriously and engage seriously in this contracting that's incredibly important to them and to their future financial rights. But so, the language in this case tells me that, there's really no ambiguity in the law that this sort of throwing up your hands and saying, I had no idea what I was doing, please save me from my own signature, isn't something that's likely to be compelling in court. And it is, as Warren discussed, it is a probate case. It is talking about rescission and kind of contracty flavored remedies as opposed to 1615. But it's a reminder that traditional contract defenses like rescission do apply in the context of premarital agreements. And the case makes the point that, because of the facts and circumstances and unique relationships involved, it's possible that circumstances relating to those defenses that might not be sufficient to rescind a commercial contract might still render a premarital agreement unenforceable. So, a minor point, but also kind of a nice reminder that we do need to be looking at standard contract defenses as well as the provisions of 1615 and the Family Code.
Right. Those are good points. Um, I was just going to say that when I draft agreements or I'm on the reviewing end of premarital agreements, I tell my clients, especially the younger one, first time marriages, that this is one of the most important legal documents you will ever sign next to your estate plan and maybe next to buying a home. And I really force them to read it, whether they want to or not. Even if it means getting on a Zoom and going it through page by page to making sure, because in today's world, a lot of people don't read anymore, especially when it comes to legal documents. So that's the estate of escrow. Nikki, did you want to add anything to that before we move on?
Well, one thing that occurs to me to mention is that I'm in a prenup agreement in which I'm the consulting attorney for the bride to be. I had my usual Zoom session where I go over and review the document with the client, sort of page by page, screen sharing on the Zoom. And I tried something that I thought would be interesting, and enabled the Zoom. I enabled the AI function of the Zoom to transcribe the meaning, not thinking that I could rely on it for complete accuracy, but I was curious to see how accurate it would be. And I was really astonished when, at the end of the session, within 2 minutes, there was a, 4 or 5 page transcript of everything I'd gone over with the client and how long it took and all the issues that I covered, and I had to go through it and interlineate my own edits, but I was really astonished. All those years I've been consulting attorney on prenups, I never had this tool before, and it was really remarkable. I'm not sure I'm supposed to recommend it, but you might try it for fun,
Yeah.
you know?
No, the Zoom AI summary is sort of
Yes.
cool. So that's a whole nother webinar on the
Yes.
yeah. But definitely when we're talking about Zooms with clients and summarizing what you've gone over, it's an important tool.
Yes, yes, yes.
Okay, so that's the estate of escrow. The other case that came down since our last presentation in February of 2022 is the marriage of last, which came down in 2023. This was an interesting case. The agreement had a waiver of spousal support, but it doesn't stop there. And this is really another cautionary tale for practitioners when they go to court on an RFO for support. So, Mickey, take it away on the marriage of last.
Okay, for Mr. Last. Before I get started on the 3 cases we want to talk about, Last, Factor, and Zucker, um, I wanted to just briefly summarize the California Family Code 1615C, which outlines the requirements that have to be found in order to support the ruling that the premarital agreement is valid. That under 1615C, all premarital agreements are presumed to be invalid unless there is a showing of 5 different factors, and the statute lays out what those factors are. Um, the the party against whom enforcement is sought was represented by legal counsel. The party had 7 days from the circulation of the final draft to the date of signing. There was full financial disclosure. No guns were involved in achieving the signature. That is no duress, fraud, or undue influence. The parties had capacity to make an agreement. And the fifth thing, that may be more than 5, but the last thing on the laundry list is other factors that the court deems relevant to the execution of the agreement. So the burden is really on the person who seeks to enforce the agreement to demonstrate that the agreement is valid. And we're also dealing with section 1612C, and that code section says that that any spousal support provision, whether it's a waiver or a limitation, is not enforceable if just from the get-go, if the person seeking support was not represented by counsel, or if, and this is a public policy argument, if the agreement was unconscionable at the time of enforcement. And in last, one of the holdings was that the appellate court has the power to review, that the court has the power to review the unconscionability at the present time of the spouse's waiver or limitation, as a obligation the court has to determine correct public policy. So if it doesn't pass the smell test, then the court has the power to hold the waiver unconscionable. But in last, there was another important wrinkle to the case. That is, well, maybe I should talk about how the case came about. The wife, there was a premarital agreement. The couple was separated. Wife filed an RFO for temporary support despite the waiver in the premarital agreement. And the trial court ordered her
Oh, wait, Mickey?
something like 80 on appeal, right? On appeal, the husband argued that the spousal support waiver was enforceable and that the court erred in making an award of temporary support. But the appellate court said, and this is where I think it's kind of the appellate court said, no, you have to have had a hearing on the validity of the premarital agreement from the get-go, and the trial court must make these findings under 1615C. And that in that they had no such findings, the court said that the order for temporary support should remain in effect. However, the husband had a remedy in that he could go back to court and seek to recapture any amount. He could go back to court, ask for a determination that the waiver was conscionable in the moment. And if that's the case, then the trial court could order the wife to disgorge the spousal support payments that she had gotten, which seems kind of like a lot of work, like why didn't they just rule on it in the beginning? But the husband didn't ask, so he didn't get, and that was the result in the appellate court. So the next case we wanted to talk about.
Mickey,
Yes.
before we leave last,
Yeah.
so
Oh, yeah.
there's a couple of procedural issues that I think we want to bring up. When I first read the case, I thought, do we do anything different in our drafting of agreements?
Oh, right. Yes.
But then in talking to some colleagues, um, it sort of came to light that maybe to help protect the spousal support waiver or limitation that we're putting into the agreement that both parties are agreeing to at that time, that we could add a provision, something to the effect of shifting the burden of proof to the person who's trying to set aside the waiver limitation in the future and having the parties acknowledge this case in re marriage of last and have them agree that they are waiving the of last, abrogating the holding of last, and agree that there's no presumption that the support waivers in their premarital agreement are unenforceable before a court determination, because that was the problem that Mr. Last faced. So whether that would hold up in court, I don't know. But Judge Scully, in light of this holding, and do you think adding a provision like that in a prenup would be something that the trial court would strongly consider in upholding the waiver until there's a bifurcated trial on the issue of temporary support?
Yeah, well, I think that the language of 1615C that Mickey helpfully outlined at the beginning of her remarks is always the starting point for the court. And I'm focusing on 1615C5, quote, any other factors the court deems relevant, right? Which is simultaneously maybe my favorite, my most favorite, and my least favorite provision of 1615. But I don't see why that doesn't give the court a hook to say anything else the court deems relevant includes specific contractual language in the premarital agreement that deals with this issue, or that's, anti-last language or something like that. I don't see any reason why I would be precluded from considering that. And I think that any other factors the court deems relevant certainly um, it seems to me, and there's no law on it, but I would think that that would cover agreements that the parties reached about this. A couple other comments, if I might. So this issue of burdens of proof in the context of enforcing premarital agreements and in the context of marriage of last, where there's a request for temporary support, is very, very confusing. And that is because, the 1615A places the ultimate burden on the person against whom enforcement is sought, right? But ESCRA, because ESCRA discusses this issue as well, and last clearly puts some kind of burden of production, at least, on the person who's trying to enforce the agreement, not the person that's trying to invalidate it. So there's this inconsistency or kind of uh, oppositionality in how the cases are interpreting the code and in terms of who has the burden of proof. Sometimes when cases are set for a long cause, trial in Department 35 on these kinds of issues, my pretrial orders include a specific requirement that people meet and confer as to exactly who has the burden of proof and who has the burden of production and persuasion and any other burden on the issues that I'm going to be deciding. And I do that because there is so much confusion about it. And I want parties and counsel to be very clear on that as they're working their cases up. I also, now am always looking at these cases from the point of view of the family law judicial officer sitting in a home court, not in, a designated trial court where we have a little bit more freedom to control the calendar. But judicial economy and when and how are these hearings going to happen, and how are we streamlining things, and how are we avoiding additional hearings, is very, very important to those judicial officers, and so by extension to parties and counsel litigating there. And to me, what the husband did in last makes a lot more sense. Remember, last says husband had requested that the issue of the validity of the prenup be bifurcated, and that the decision about whether or not to award temporary support be continued until after that decision had been made. And that's sort of instinctually how I would have approached it had I been representing Mr. Last, because it's sort of unclear to me what a facial review for 1615C factors looks like in reality on the ground, and whether that's something that would be handled on the papers. It seems to me that that is something that easily might require an evidentiary hearing. And, so that means that if there's this issue of temporary spousal support requested when there's a prenup waiving it, we're setting up a little mini, perhaps trial on duplicative issues, but in a context where the person has a burden that isn't the same as the burden that would be at the ultimate trial. And, I worry that that's inefficient. So I'd say, first of all, think about, if you're gonna be the one who wants to enforce the agreement, you're gonna have to make a simple expedited facial showing to a trial court that addresses those 1615C factors. And some of those seem pretty easy to handle on the papers in an RFO context, right? You could, prove that someone was represented by counsel by attaching a copy of the attorney certification or something like that. Or you can prove the 7 days by, confirmation, or by the recitals of the agreement if you've included recitals about the timing, stuff like that. But, the any other factors, people aren't necessarily gonna know in advance. Or, 1615C4, where it's talking about things not being executed under duress or fraud or undue influence. And practically speaking, to me, those sound like things that would be hard to decide in an RFO context on papers, and might require some kind of evidentiary hearing. And, so, it remains to be seen what this is actually gonna look like. But I would suggest that if you're litigating this issue, very, very early on, you meet and confer to figure out, number one, are we all on the same page about who has the burdens and what that's gonna look like? Number two, last makes it clear that for better or for worse, you have to file a specific RFO that asks the court to make these findings. So don't forget to do that, even if you think it's dumb, or would have been folded into your bifurcation request. That's logical, but if you're complying with last, it's very clear that they're requiring people to do that. And maybe talk to your opposing counsel about then having a stipulation to bifurcate the issue, and sort of, trailing that RFO to the time of the bifurcated trial on validity. But at least you've got it on file so that you know that you're in compliance with last. And the other thing that last tells us, I think, is that it's incredibly important to make sure that you've clearly requested that the court reserve retroactivity over the issue of the temporary support. Because if we are, we've kind of got this interim thing that might permit some support, but at the end of the day, somebody might be able to, the person challenging the agreement might be able to meet that burden, and that means there's going to be this sort of weird recapture. I mean, you've got to make sure that the court retains the ability to do that. And I see at one level why retroactivity may be the best that anyone can do to protect the competing rights of the parties here. Last talks
Mm.
a lot about the public policy surrounding temporary support, and we want to make sure that people are able to maintain the standard of living and that their economic circumstances aren't so oppressive or unstable that they're unable to litigate the validity of these agreements as they have the right to do. But at the same time, I have some concerns about retroactivity really being able to ultimately make everybody whole in an appropriate way. Because people that have a legitimate need for temporary spousal support aren't saving it, they're spending it. The whole
Mm.
point is they need it in order to meet their living expenses. And so, if you have a community estate that's big enough or other assets or something to where at the end of the day, even if and we all know temporary spousal support sometimes is not so temporary, and those orders are in place for years and years and years. Um, if you've got property at the end of the day that you can use in order to make that right, that's one thing. But if there is not a sufficient amount of property and, this whole procedure that's being set up is, setting up that somebody might have to repay money that they spent on their living expenses, I have some concerns about whether or not that actually is a good way to make people whole, although, it may be the best that we can do under the circumstances.
Right. Thank you, Judge Scully. All very good points. I have a feeling this isn't the last time we'll be hearing about this case of law. Okay, so we're going to switch gears a little bit and focus on a couple cases where spousal support waivers or limitations were held unconscionable at the time of enforcement. So, switching our brains to time of enforcement, when the parties separate, what the court looks at, because these are, in my opinion, very factually driven. So, Mickey, talk to us about Factor and Zucker.
Okay. They're in a way they're kind of similar in that um the wife in both cases, well, in both cases there was an imbalance of bargaining power. The wife didn't have as much education as the husband. In the case of Factor, which is a 2013 case, the wife had pretty much stayed home. I think this is the one where she had 6 kids, or is that Zucker? Zucker is the 6 kids. So Factor, the wife had worked intermittently. Um, she was a high school graduate. She had 2 kids. That's in this Factor case. Husband was a graduate of Harvard Law School. At the time they got married, he was earning about $1 million annually, and he had $3 million in separate property. Um, the husband, this is 2013, drafted the premarital agreement. And at the time he handed the wife the draft, evidently he told her that the spousal support waiver was non-negotiable. So the court found here that the spousal support waiver was unenforceable at the time of enforcement. It also found, by the way, that it was unenforceable at the time of execution, but that it was unenforceable here at the time of enforcement and refused to uphold it. And Zucker is similar, later case, 2022. And in that case, the wife had agreed in the premarital agreement to a limitation on spousal support of limiting spousal support to $6,000 a month. At the trial, her forensic accountant had testified that if you were to make an order that would give her enough to meet the marital standard of living, that under the income available approach, she would be entitled to $86,000 a month, at least under the expenditure approach, she would be entitled to at least $37,000 a month. In this case, the wife was unemployed all during the marriage. She had these 6 kids. It was a long-term marriage. And the husband had amassed a huge fortune, and the wife had had mental health issues. So the court said that it was not necessary to find that the agreement was unconscionable at the time of execution. Although I think here that it could be found because of the imbalance in bargaining power, but rather the court said that it has the power to shape public policy regarding premarital agreements and to declare the premarital agreement unenforceable based on the circumstances that existed at the time of the evaluation of the validity of the agreement. So I think actually, when I read both of these cases, my sense is that, and maybe that's the practice pointer, is if you know facts about the parties, like the guy went to Harvard Law School, wife never had an education, a red flag should go off. And like maybe there would have been a way, although I doubt it in these cases, that you could have included in the agreement some acknowledgement of the imbalance of bargaining power, perhaps. I don't know. Judge Scully, I'm not sure if that would even hold up, if you said in the agreement that the disparity in their earning power would not be a basis for overturning the agreement. I'm not sure. But
Yeah.
both those cases are clearly, I mean, the facts were there from the very beginning that there was an imbalance in bargaining power.
Yeah, there were a lot of issues going on in Zucker.
Right.
Because the 3 of us have been around for a while, we happen to know some of the lawyers involved in the Zucker case, and it went on for years and years. It's
Still,
separate as the 7 years. What was it?
still going on.
Still going on, but it is the most current reported case in California. Um, that is an example where the court set aside a spousal support limitation. So if you actually read the original trial court opinion, which was done by Judge Schneider, it gives you a very good view of what the trial court looked at in examining the competing forensic accountants, the marital lifestyle, the needs of the wife, and how it came to its conclusion. A case where a spousal support waiver was not held unconscionable, it was upheld, was In Re Marriage of Howell. And that was a 2011 case. That one, the court found the agreement was executed voluntarily and that the terms were not unconscionable. And the facts, sort of bear that out. The parties had comparable net incomes. They executed their agreement in 1999. So that was before the enactment of the current iteration of Family Code Section 1612. The trial court ruled that the wife failed to prove that the agreement was unconscionable, finding that the parties had made fair, reasonable, full disclosures of property within the agreement. Additionally, the trial court in that case found there was not a great disparity in the income of the parties and their respective estates at the time they entered into the agreement, established that there was not a significant inequality of bargaining power, which goes to your point, Mickey. So the appellate court affirmed the trial court's conclusion that the spousal support waiver in that agreement was not unconscionable. So, this issue as a practical matter, when you're on the reviewing or drafting side, and especially when you're on the drafting side and your client wants a waiver or limitation, and clients say to me, will this hold up? The answer has to be, I don't know. This is our state of our law. Our family code 1612 is what it is. It's totally factually driven to some
Right.
futuristic point in time where none of us have a crystal ball. That's the problem with these. We do the best we can. And that's what I tell clients. They can offer to do anything they want on the property, but when it comes to support, it really is in a state of flux. So, Judge Scully, why don't you discuss, some of the factors that the courts have looked at and any factors that also you think about that would be important to you in looking at whether a waiver limitation, you're looking at is unconscionable or not?
Sure, I'm happy to summarize that. And I think drawing on the comments of each of you, one of the overarching considerations has to do with whether there's a significant inequality of bargaining power and what specific steps were taken in order to level that playing field. And, it may be that if you have someone that, is, a certified family law specialist on one side and somebody that doesn't have formal education at all on the other side, or, just to use an example, I mean, it can't be true that it would be impossible to ever construct an enforceable agreement involving the people with that level, but you would have to look at what concrete steps were taken and again, competent counsel, again, having it all documented, perhaps mediating the terms of the premarital agreement and having the additional layer of a mediator or, some kind of collaborative process. Those are certainly options. Making sure people have enough time, making sure, just what, and it is going to be fact specific what those inequalities are um uh, it's an opportunity for creativity on the part of the drafters working with parties who you sincerely believe want to have this agreement and have the capacity to enter into an agreement that is workable and they have their reasons for wanting to do it to take the steps that you can think of in order to convince someone, the hypothetical judicial officer at the end of the day looking over your shoulder to say, how can you make me feel okay about this given these inherent inequalities? What concrete steps did you take?
Yeah.
And I will say, I will cop to have being around forever, but I just wanna make it clear, I haven't had any conversations with any of the attorneys involved in Zucker or any of these other cases, so I don't have any independent knowledge of that. But when we look at the cases, you can see, the courts are focusing on education levels. That seems to be something that's important. There's language in Zucker about mental health issues. I think one of the parties perhaps had an eating disorder, and there was an indication that there had been some kind of trauma background. There's a lot of work and research about how to practice law in a trauma informed way, and maybe useful to look at that if you have a client that's had that experience again, as part of this exercise of creatively taking documentable steps um, to levelize the playing field. The courts are looking at earnings and earning capacity and income. Some of these, factors that start to sound a lot like 4320 factors
Mhm.
all seem to be relevant and people's net worths whether again there's some kind of health issue or mental health issue or disability and what steps have been taken there something that hasn't been specifically mentioned in cases that I've seen, but obviously is the subject of kind of growing statutory language and awareness in California is this issue of coercive control and if there's, a domestic violence component or coercive control, facts or allegations, or perhaps a prior case involving the parties and now they've reconciled and are trying to do this, then, or at the time of the enforcement when the court is looking at it, I think that facts tending to show that there was coercive control involved certainly relates to that inequality of bargaining power and whether there was informed consent. And in, I think, both Factor and Zucker, there was reference to what the guideline number would be. And I think that's interesting. So, if you are litigating this, and if it's a situation, well, I guess it could be if there's a waiver or if there's a limitation, but look at what the person would get under the agreement. And if guideline support would be $800,000 a month, then maybe that's kind of an efficient, effective way to point out that that someone might have concerns about unconscionability. So don't forget to run guidelines and compare those. I think that's definitely something that the court could consider. And then just always in the back of everyone's mind when you have a very fact intensive analysis like this, is the court's consideration of the credibility of the parties. And, it may not be its own unique separate factor that the court's looking at, but it's certainly a lens through which the court is considering evidence about all of these other factors. And you can't understate the importance of the court's credibility determinations in this context.
Okay. So again, these waivers of spousal support in agreements, a little bit of a landmine. We do the best we can as practitioners. We still do them. We have to make sure our clients understand that this part is not guaranteed in stone in the future. And because we don't know what the future will hold. Um, on the other side of the coin, our last issue that we're going to talk about for the remaining minutes, and I notice we have 3 questions, so we'll try and get to them. It um this is something that I'm asked all the time when more and more agreements that I seem to be either reviewing or drafting are ones where there is limited community property. It's just what couples want, whether it's a first time marriage or later a life marriage. So more and more I seem to be dealing with agreements where parties are entering into agreements. They are proactively agreeing will be limited community property despite the disparity in earnings and assets at the time they're entering into the agreement. And assuming, and this is really ultimately a question, for Judge Scully, but Mickey, for you to weigh in, assuming parties follow the statutory framework of Family Code 1615, they cross their T's, they dot their I's, they have financial disclosure, they follow the 7-day rule, they both have independent family law, competent counsel. And let's assume they don't even have a waiver or limitation of support. Put that aside. But in the property part, it is clearly unequal at the beginning, and it is going to be even more unequal if, gosh forbid, they get divorced. I'm asked all the time, will this agreement be upheld? What's the consideration for the bride waiving all of this? And will it be unconscionable? And it's my opinion, and Judge Scully, you can correct me, that you don't need quote unquote consideration for a prenup. That's what Family Code 1611 says. It's different than a contract in that way because of the type of agreement you're entering into. And if people want to enter into an agreement with counsel and it's voluntary and full knowledge, knowing that you're unequal at the beginning and you may even be more unequal at time of separation, it's their right to do it. There may be other issues, moral, ethical, therapeutic, where they need to talk about this because there's resentment that that's not the legal issue. And so, the question is that agreement that follows the statutory framework of 1615, despite the inequality and putting aside the spousal support section, going to be upheld as valid under our family code section? My opinion is yes, but this is where I open it up to Mickey and Judge Scully for their opinion.
Did you want to go, Mickey?
I wanted you to go first.
Yeah, I'm happy to do that. And again, there are the stereotypic example that that we customarily think of is where it's a moneyed husband and where it is a bride who has fewer financial options. But let's remember that many times it is the groom that's waving, and that these are issues that are very present in same-sex relationships. So, one, we know that the gender of the people involved isn't going to be determinative, and that this looks, all kinds of ways. And let's remember too that we also have the 1615A inquiry about, voluntariness and, the other things. I mean, I think that there isn't any way to guarantee any ultimate result. The best that you can do is be mindful of all of these factors and do your best to document that. And I think it's by design that just the door has been left open for an exercise of discretion on the part of the judicial officer. The cases talk about courts shaping public policy with regard to these waivers. They want to make sure that the family court sitting in as a court of equity at the end of the day is sort of a failsafe, I think, to protect people if something is really truly unconscionable. But I think there's also really something to be said here about judicial philosophies and different courts have different points of view about the role of the court in intervening to kind of save people from their signatures. And on the one end, you have an idea that we want to respect private ordering and private contracting and the capacity of individuals to plan for themselves what they want their finances and their relationships to look like. The law has lots of protections built in to make sure that there is informed consent happening. And, if those are followed, it is respectful of litigants and, also stops chaos and allows people to sort of rely on what the agreement is going to look like, right? Because it creates chaos and instability if people operate financially or relationship wise, assuming that something is going to look a certain way. And ultimately, that turns out not to be true. And then on the other side, that it is a court of equity. There's important public policies about making sure that people are able to support themselves and not become, dependent on family or on the state at the end of the day, that they have the resources available to litigate their cases. And, we didn't really talk about attorney fees in particular, but I think that it's very intertwined, these waivers or limitations on fees, and that, that it's by design that someone has to look at the totality of the circumstances at the end of the day and be comfortable that something is fair and appropriate. And if it's not, that the court should step in and make its own determination, and that is more important than honoring whatever the agreement of the parties were at the beginning. And I think that there's merit to both of those, perspectives on opposite sides of the spectrum. And you will certainly find judicial officers that tend to lean in one direction or the other, or have a certain philosophy about really how interventionist the court should be in the private relationship ordering.
Good point. Mickey, do you have anything you want to add to that?
And just the conversation, this part of the conversation reminded me of a point I wanted to make in last that sort of seems somewhat related. In last, the the um the agreement, the premarital agreement provided that in lieu of spousal support, the wife would get X number of dollars in payments through the course of the marriage. Plus, the husband had agreed in the premarital agreement to transmute the his separate property house to community property. So I don't have an answer, but the question is, if the spousal support provision is held to be unconscionable and severed from the rest of the agreement, does the rest of the agreement fail for lack of consideration for the transmutation of the house to community property and the payments to the wife throughout the marriage of the cash? Just a question.
Yeah, it's a good point. It's 1:30. I don't know if are we done? Are we people still on? We have some questions.
So,
I
yes,
don't
if
know.
you'd like to take the time to answer some, please feel free.
Let me see if there's one or two here that hi April.
Hi, I was just gonna say, yeah, if you wanna go through a couple questions, you have time. People can stay as long as you'll like.
The first one, I have no idea. Here's the question. Can arbitration clauses for lump sum upfront consideration push all issues into binding arbitration, or is that too viewed as presumptively invalid? Can arbitration clauses for lump sum upfront consideration push all issues into binding arbitration, or is that too viewed as presumptively invalid?
Yeah. Well, off the top of the court's head, um, there's arbitration is authorized and permitted in certain contexts in family law cases, but not in others because parties can't reach agreements that deprive the court of jurisdiction, for example, over custody and visitation issues or over child support issues. We wouldn't be contracting about custody and visitation in a premarital agreement anyway for that reason.
Right.
I don't, I think that in some contexts it is permissible to contract to binding arbitration. And I don't know of any law that it would be presumptively invalid, except just being mindful of that issue of depriving the court of jurisdiction over things.
Okay. And Joseph asks, is there any case or statutory law addressing drafting a premarital agreement for another attorney who is husband to be? Any special rules to follow or helpful hints to ensure a premarital agreement for an attorney is enforced? Nobody else, Joseph. No, just kidding. I mean, I'm not aware of any special rules because the attorney to be groom is like any other groom as far as I'm concerned.
Right.
Then they ask a lot more questions and you want to cross your T's and dot your I's. But I'm not aware of any case or statutory law.
No.
But
Okay.
usually when it comes up in these kinds of cases that somebody was an attorney, that is not a good fact for the
Yeah,
it's the attorney because of this overarching concern about inequality of bargaining
Yes.
power. So, we talked about it a little bit, and, I don't know that, there isn't a silver bullet or a panacea, but if someone has, more sophisticated knowledge, then you make sure the other person has representation and adequate time and explanation and any sort of accommodations or anything else that they would need in order to try to equalize that. And it's that kind of thing that, I was suggesting is really an opportunity for creativity on the part of the people representing, these parties and trying to, honor whatever their intent is about how they want to operate. But it goes to the inequality of bargaining power.
Yeah.
Yeah.
That's a good point. All right, another one by Jack. Jack, you are drafting prenups. All right. Could any such pre-signing mediator be the agreed upon arbitrator if binding arbitration selected by both parties with approval of both counsel pre-dispute? Could any such, well, just off the top of my head, most mediators that mediate prenups are not judges. They're family law attorneys. So number one, you would not want you would not use them for binding arbitration in the future. I the question is then if you're going to have to use a retired judge, let's say, to mediate your prenup, could that judge be used as the binding arbitrator later on, I would think no from a strategic point of view, but legally, I don't know the answer to that. Judge Scully, I don't know if you know either.
You know, again, this is no great wisdom off the, just sort of my gut response. And if these issues came up in Department 35, I would certainly be willing to consider any authority anyone has to the contrary.
Yeah.
But I think it creates an issue regarding mediation confidentiality.
Confidentiality.
Because then if an agreement is mediated, then those communications are confidential, and the California Evidence Code precludes that person from being called as a witness, something like that. And what would then, if you have the same person being the arbitrator, that means the decision maker is someone that has been privy to all of the confidential communications, and you might or might not want that. But so I just see an immediate issue about mediation
Yeah.
confidentiality.
Jack asked, do you use video recording at signing? I don't anymore, Jack, to be honest. We used to do it in the olden days. But nowadays we just don't. And in fact, I still am old school, as is Mickey, when I still do originals in person
Right.
by counsel and parties, that more and more I'm dealing with people that actually don't even keep the original copies anymore. More and more lawyers are having the clients keep the original and are only doing digital copies. So I don't use video recording. That's not to say if you have a big concern about the mental health of a party, or if there was,
Right.
extreme resentment or unhappiness and you want to protect your client, then you should have it video recorded.
Right.
Okay. Christina asks, I heard in another seminar, Christina, that attorney certifications typically included in premarital agreements were not required or recommended. The concern expressed was that this may impact liability of the attorney involved. What are your thoughts or comments on this? Well, we all have them in ours.
Yeah.
I would think, if anything, the attorney, the more concern is the waiver of attorney-client privilege, and to
Right.
make the parties on notice that when this attorney certification says, I've gone over this agreement, my client indicates they understood it before they signed it, that to me, it's important that the party understand that if there's ever a dispute later about the agreement that puts the client at odds with their attorney, that their attorney can produce any and all evidence to show that their client understood the agreement. So that's the potential waiver of privilege. But to me, the attorney certification enhances and protects the lawyer, because they have a document signed by their client saying, yes,
Yeah.
I agree to this. Mickey, I don't know if you have any further thoughts on that one.
Yeah, I agree with you, Lauren. That the fact that I mean, I would never do a premarital agreement that didn't have attorney certification.
Yeah.
Okay. Let Judge go.
I'm being summoned. So and unfortunately I think we have to stop
That's
there. But
very
thank
good.
you for your excellent and thoughtful questions.
Thank you so much, everybody. And
Thank you.
April, if you're still on, and everybody, thanks so much. Have a good day. Don't
You
fork
may
and
be
draft.
eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.